From the WATE.com Digital Center, answering your legal questions, this is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Great troubles and having troubles getting services, and so he was brought home, and while here he still continued to have difficulties with getting the help he needed. So he at one point checked himself into the old St. Mary's, now the Justice Center there, and he at that point was declared AWOL by his unit because he had not returned to Fort Knox up in Kentucky to rejoin with his assignment, and it was actually, he had a note from his doctor telling him this guy is not fit, but that's the military. They have the different system, different standards.
Right.
Now, all of that actually eventually more or less came out in the wash, but then fast forward to last weekend, or actually Monday, when the name Julian P. Goodrum, and we had to go and look because he at the time had been going by Phil, but it's him.
We found him, and do you want to take a moment? Let's listen to what he had to say to us back there now more than 20 years ago.
When I'm into a severe panic attack, I come extremely nervous, I shake, breath gets short.
Okay, so fast forward to the murders of a couple in Loudon County.
Yeah, and this is two people found dead over the weekend. This was a piece of property where, according to the sheriff, that he had stayed at times, Goodrum had, and that this was someone who knew him. This family, I guess, and we don't know the exact circumstances of when and where, but there had been checks made. He had had interactions with law enforcement in the prior 2 days before the alleged murder, and they had not taken whatever intervention they might have taken. Then, before the murders were actually discovered, Goodrum had another interaction with law enforcement and wound up being taken to a hospital for a mental evaluation. And it was actually at that point where someone had discovered the bodies, and then he was arrested.
And here we are.
Yeah. So we brought Greg in because we just absolutely have to figure that mental health is going to be an issue in this case. But Greg, it's an issue in a lot of cases, and that doesn't necessarily mean what you think it might, at least in the public side when mental health is raised. Greg, first let's start with, there's kind of a two-pronged situation here. Let's first start about getting this case to the courtroom. How does someone be declared fit to stand trial?
Well, Jeff, we don't want to talk about this case specifically,
Correct.
But typically when you look at a mental health defense, there are two components, and one is someone competent to stand trial. And basically the test is, can you reasonably assist your attorney in your defense? Can you understand the legal system? Can you provide information? Can you make decisions, et cetera? Now that determination is typically made by experts, mental health experts, psychologists, psychiatrists. Also, you want to get a lot of anecdotal information. You will get someone's medical history. Very important. Now, it's just not a one-sided endeavor. So if you raise a mental health issue, then the state has the opportunity to have your client evaluated as well. Now,
and that could be whether they understand what's happening in court, right?
Correct. And that's important on a lot of factors. Let's just say the case ended in a plea. Statistics show that 92% of all criminal cases resolve themselves with a plea agreement, the judge and the court and the lawyers want to ensure that it's a knowing, intelligent, voluntary decision. If you don't understand it, you're not competent, it obviously cannot be.
You mentioned mental health history. It depends on what the history is. And again, not getting into specifics, but in a case that could be similar, they've happened before, where there has been that history and someone tried to get help, said they couldn't. Who could be held liable here, if anyone?
I don't know that anyone can be held liable in case you knowingly put somebody, release somebody that was suicidal or visibly, violent, etc. But the second prong is the one that's the most important if you're the defense lawyer, and really the public, I think, has a fundamental misunderstanding. If your defense is you were not guilty by reason of insanity at the time, people think that's a kind of like Vegas. Everybody wins, everybody hits the jackpot, everybody malingers, plays crazy. So back to your point, Lori, it's important that someone has exhibited signs of mental illness before, so they just didn't create this defense after a crime was committed. But Jeff, it's a extremely high standard in Tennessee. The law changed in the early 90s. And you have to show two things. One, that the citizen accused is suffering from a substantial mental disease or defect, not just a mental illness, not just that they've had depression or other issues. And secondly, as a result of that substantial mental illness, the individual cannot appreciate the wrongfulness or nature of their conduct. A very high standard. And in every criminal case, the state's got to prove your client guilty beyond a reasonable doubt. If you raise a mental health defense, it's up to the defendant to prove his mental illness by clear and convincing evidence. So you flip the script, it's your burden of proof, and statistics show that it is a very hard road to hoe here in the state of Tennessee.
Well, Greg, I want to talk about that because and I know you've described this as a battle of experts, but ultimately, whose decision is it? Is it up to those experts? Is it up to the judge? Is it up to a jury, perhaps, to say, yes, we believe this person is falling under this category or that?
Wow, that's a good question. There was a study done by David Rayburn in Nashville, and basically in a 10-year period after 1996, when the law changed, there were only 13 cases that were successfully resolved by not guilty by reason of insanity. Every single one was the result of a plea. So you have the prosecution's experts agree, defense experts agree, but then the lawyers have to agree. So who has to agree? I have cases where all the experts agree somebody is legally insane at the time, but the prosecution says, not their choice. It's for a jury to decide. So ultimately, Jeff, who decides? The jury.
Could that then potentially come up on appeal, for example, if a case were to go to a trial and then the person was declared fit to stand trial, declared whatever mental illnesses they were facing, that they were still found guilty, could then years later or months later or at some point in the future a new attorney or a new set of evidence be presented to say, no, actually that person wasn't whatever,
and we can prove it?
Yes.
Yeah.
Well, you basically would have to prove, and I've crossed this hurdle here in Knox County, that someone was ineffective in terms of how they went about that process. So not really that they were legally insane at the time or not, but basically whether the lawyer was effective in captaining that ship and dealing with experts, choosing the right expert, vetting that expert, presenting the right type of defense. But here's the thing, it's amazing when you select a jury in voir dire. And I never anticipated this. I did it recently here in Knox County, but when you ask individuals on a prospective jurors, can you accept a mental health defense if someone's not guilty by reason of insanity? If we prove it by clear and convincing evidence, Lori, people's heads start spinning. And it was amazing the large amount of people that viscerally said they didn't believe in it. They should be punished. They should be hung. And we had juror questionnaires, and they're like, don't believe it, abolish it, hang them.
They call it evil, not insanity.
Yeah.
And doesn't it depend on the heinous of the crime
Well,
when it
it-
plays into things like this, when you determine.
And it does, but it shouldn't if they follow the law. But I think it's kind of got like the Las Vegas jackpot theory. Everybody thinks you go to Vegas, and what happens when you pull that slot machine?
You win.
You win. You know what? Everybody thinks that everybody gets off every day by insanity defenses. And here's the shocking part of this. Statistics show that it only prevails in the state of Tennessee 2 to 3% of the time.
Wow.
So imagine you're coming up with a defense. You've got the greatest experts in the world. You've got the medical records that support it, and you say, I feel pretty good about this case, and we got a 3% chance of winning. Remarkable.
Wow.
But the other thing that's important about a mental health defense, let's say in a case where you're charged, which most serious felony homicides are, with first-degree murder, which is a premeditated killing of another. That means planned. So, if somebody is experiencing mental illness, you argue that they cannot plan, premeditate, have that requisite intent for first-degree murder. Then next would be second-degree, a knowing killing. If that doesn't happen because of the proof, voluntary manslaughter. So mental health, even if somebody is not guilty by reason of insanity, it can be incredibly important in negating an element and obtaining a different result.
All right. We're going to keep watching this. You want to talk more at 5:30?
Sounds good.
We'll boil it down for you then. Thanks for being with us.
Stephen.